All right. So before you on the screen is this defendant's motion for clarification of ECF number 159. So it was the district judge's order on ECF 159 that overruled the defendant's objection to the magistrate. And so I'm going to go over this again and then show you what she is asking for clarification about today. All right. Please be respectful in the chat and with your comments. You can also email me right now at unwinewithteddy@gmail.com. Again, this is a working live. So this is in the United States District Court, Eastern District of Michigan, Southern Division. Evans, the plaintiff, versus Robertson, defendant, and the Honorable Judith E. Levy, Magistrate Elizabeth A. Stafford is the judge there. Defendant's motion for clarification of ECF number 159. She writes, defendant appearing specially and without waiving any jurisdictional service, process, First Amendment, anonymity, or appellate objections, respectfully moves for clarification of the court's May 26, 2026 order overruling defendant's objections, ECF number 159. To the extent the court construes this request as seeking reconsideration, defendant seeks only limited reconsideration under Eastern District of Michigan law, Rule 7.1H2. Defendant does not file this motion to relitigate the underlying identity disclosure orders. Defendant seeks only clarification that defendant's response to the order to show cause ECF number 150 was timely filed and should be considered before any future finding of contempt, sanctions, willfulness, bad faith, or defiance. 1. Limited clarification requested. Defendant respectfully requests clarification that ECF number 150 remains part of the record and should be considered before any contempt or sanctions finding. If the court construes this motion as one for reconsideration, defendant submits that clarification is warranted under Local Rule 7.1 H2A because ECF number 159 does not appear to address the distinct role of ECF number 150 as defendant's timely response to the order to show cause. The mistake defendant seeks to clarify is not the court's ultimate ruling on the identity disclosure orders, but the absence of any statement confirming that ECF number 150 was defendant's timely response to the order to show cause and should be considered before any future contempt or sanctions determination. 2. Limited relief requested. ECF number 159 states that defendant's objections are overruled because defendant did not show that Magistrate Judge Stafford's March 3rd, 2026 order to show cause was clearly erroneous or contrary to law. ECF number 159 also states that defendants' good faith judicial review and constitutional arguments were unavailing. However, ECF number 150 specifically addressed why contempt and sanctions should not be issued. In that filing, defendant argued that her conduct reflected a good faith legal dispute regarding irreversible identity disclosure while judicial review was pending, not willful disobedience or contempt. 3. Section 3. ECF number 150 was defendant's response to the order to show cause. In this section, the March 3rd, 2026 order required defendant to show cause by March 24th, 2026, why she should not be held in contempt or sanctioned. ECF number 159 describes ECF number 144 in that manner. Defendant responded on March 24th, 2026. ECF number 150 is titled Defendant's Response to Order to Show Cause. In that filing, defendant appeared specially and without waiving jurisdictional objections and argued that the record reflected good faith efforts to preserve constitutional rights through proper procedural channels, not contempt. ECF number 150 further explained that defendant sought Rule 72A review and a stay, preserved First Amendment anonymity objections, disputed waiver, and argued that contempt or sanctions were not appropriate where the dispute concerned irreversible identity disclosure. Hang on. Section 4. Clarification is needed because non-compliance and contempt are distinct issues. Defendant understands that the court has distinguished between the prior identity disclosure orders and the late order to show cause. ECF number 159 states that ECF number 144 did not itself order disclosure, but required defendant to show cause why contempt or sanctions should not issue. That distinction is why clarification is necessary. Whether defendant complied with ECF numbers 118 and 124 is one issue. Whether defendant's conduct warrants contempt, sanctions, or a finding of willfulness, bad faith, or defiance is a separate issue. ECF number 150 addresses the second issue. Defendant respectfully submits that any future contempt or sanctions ruling should address ECF number 150 before finding willfulness, bad faith, defiance, contempt, or sanctionable conduct. Section 5. Defendant does not seek to relitigate the underlying orders. Defendant does not seek, through this motion, to re-argue the entire identity disclosure dispute. Defendant seeks only limited clarification that 1. ECF number 150 was defendant's timely response to the order to show cause. ECF number 150 preserved defendant's constitutional service, jurisdictional and anonymity objections, and 3, ECF number 150 should be considered before any finding of contempt, sanctions, willfulness, bad faith, or defiance. Section 6, conclusion. For these reasons, defendant respectfully requests that the court clarify ECF number 159 for the limited purpose of confirming that ECF number 150 remains preserved and should be considered before any contempt or sanctions finding. So now let's go. All right, I have the district judge's order. This is ECF number 159 that the defendant is referring to, also referring to what she says is her show cause ECF 150. I pulled that up as well. So let's go over this recent order that was just filed on May 26th. Well, not too long ago, last week. And it is ECF number 159, order overruling defendant's objections 152. Before the court is defendant Daniel Robertson's objections to magistrate judge's order, ECF number 152. Defendant asked the court to set aside the magistrate judge's order compelling identity disclosure, ECF number 144, at page ID 3435. Defendant appears to reference Magistrate Judge Elizabeth A. Stafford's March 3rd, 2026 order requiring defendant to show cause by March 24th, 2026, why she should not be held in contempt and sanctioned for her defiance of the undersigned orders to disclose her legal name and postal address, ECF number 144. Footnote, Daniel Robertson is apparently defendant's alias and not her true name. For the reasons set forth below, defendant's objections are overruled. Legal standard. Federal Rule of Civil Procedure 72A provides that for non-dispositive pretrial matters where a magistrate judge issues a written order, a party may serve and file objections to the order within 14 days after being served with a copy. A party may not assign as error a defect in the order not timely objected to. The district judge in the case must consider timely objections and modify or set aside any part of the order that is clearly erroneous or is contrary to law. Federal R. Civil P 72A. The Eastern District of Michigan Local rules state that objections under Rule 72 must A. specify the part of the order to which a person objects, and B. state the basis for the objections. Eastern District, Michigan, Local Rule 72.1D. This standard requires the district court to review findings of fact for clear error and to review matters of law de novo. Bissig versus Time Warner Cable Incorporated, 940 F3D 205 219, 6th Circuit 2019, quoting EEOC versus City of Long Branch 866 F.3D 9399 3D Circular 2017. A factual finding is clearly erroneous when, although there is evidence to support it, the reviewing court on the entire evidence is left with the indefinite and firm conviction that a mistake has been committed. Quoting United States versus U.S. Gypsum Company 333, U.S. 364, 395, 1948. An order is contrary to the law when it fails to apply or misapplies relevant statutes, case law, or rules of procedure. Quoting United States versus Winsper, number 308CV 631H 2013 WL, or that's Westlaw 567 3617. So all of that together is actually, well, I'll just read it like that. At 1 WD, Kentucky, October 17, 2013. Analysis, Section 2. On March 3rd, 2026, Magistrate Judge Elizabeth A. Stafford issued an order requiring defendant to show cause by March 24th, 2026, why defendant should not be held in contempt and sanctioned for her defiance of the undersigned orders to disclose her legal name and postal address, ECF number 144. As with her motion to stay, Judge Stafford's order to show cause, defendant interprets Judge Stafford's order as requiring defendant to disclose her identity, and claims that requiring her to disclose her identity would create harm that is permanent and irreversible, ECF number 152, page ID 3425. Again, I'm pausing because I'm thinking about what I've pulled up and when these orders and responses were created. Filings. Let's see, this is page 3. Let me just highlight that for a second. This is ECF 150, the defendants. I believe it's her show cause that she wants Judge Levy to consider before ruling on, again, I'm just pausing because I'm just thinking about some, on contempt and sanctions. Okay, so I have all of these lined up. Defendant's response to show cause, filed 3/24/2026. All right, so again, I'm reading from ECF 159. It's the judge's order on ECF 152. She says, I continue, but defendant, as with her motion to stay, misunderstands Judge Stafford's order to show cause. Judge Stafford's March 3rd, 2026 order did not order defendant to disclose her legal name and postal address. It ordered defendant to show cause why defendant should not be held in contempt and sanctioned for her repeated failure to follow the undersigned's orders. Other orders in this case required defendant to disclose her legal name and postal address, ECF number 118-124, and they remain in full force and effect, and set forth in Judge Stafford's order to show cause. Judge Levy twice ordered Robertson to disclose her identity, and Robertson defied both orders, ECF number 118 and 124. Although Robertson moved for reconsideration of the first order, Judge Levy struck that motion because it contained a fictitious citation, ECF number 121 and 124. Robertson thus did not properly appeal Judge Levy's orders and instead chose not to comply, ECF 144, page ID 3209 through 10. And as explained in Judge Stafford's order, a party's disagreement with a court order is not an excuse to disobey it, page ID 3212. Defendant's objections repeat her arguments that disclosing her legal name and postal address would violate the law or cause her harm, ECF number 152. She also claims that she acted in good faith, has not defied or disregarded this court's authority at any stage of these proceedings, and has consistently appeared, responded, and sought judicial review of orders she believes implicate significant constitutional concerns, page ID 3411 through 12. These arguments are unavailing. It is undisputed that the court ordered defendant to reveal her identity on December 4th, 2025, ECF 118, and December 29th, 2025, ECF number 124, and defendant did not comply with those orders. As such, defendant's objections do not demonstrate that Judge Stafford's order to show cause is contrary to the law or clearly erroneous. Defendant's objections are overruled, ECF number 152. So she ruled, the district judge in this order overruled ECF number 152. All right, so what she's saying here in her filing that was docketed today, if the court construes this motion as one for reconsideration, defendant submits that clarification is warranted because ECF number 159, which I just read from, she's saying does not appear to address the distinct role of ECF number 150 as defendant's timely response to the order to show cause. The defendant filed, I believe it was on the same day. Let me look at, filed March 24th, defendant's response to order to show cause. That's ECF number 150. This is the one that she is arguing to get clarification if this should be considered before a ruling on contempt and sanctions, and that it wasn't considered in her order, recent order, overruling the objections in, I believe it's defendant's ECF 152. So I need to pull that, but I'm going to go over this one too, because in this response, I want to see if she responded to why she should not be held in contempt or sanction, since she is asking the court or stating to the court, I'm going to put it in my own words, that this wasn't included in her recent ruling. She could still rule on this separately, but I'm just thinking out loud, okay? Now, all right, so let's just go here. Conclusion and request for relief. Let's see what she's conclusion is in her ask in this 152. This objection presents a narrow issue, whether a defendant who has consistently asserted anonymity and First Amendment protections can be deemed to have waived those rights. The record demonstrates that she did not. Defendant appeared, especially at the outset of this litigation, and expressly preserved her rights, including the right to challenge identity disclosure and maintain anonymity. ECF number 28. She continued to raise these issues in subsequent filings and including ECF 39, 49, 77, and 82, where she repeatedly objected to compelled disclosure and invoked First Amendment protections. Now I remember this. The identity disclosure requirement did not arise until ECF number 74, and defendant responded promptly thereafter by raising constitutional objections. What she's arguing here is that she waived, the court is saying that she waived her, wait a minute, that she didn't assert her First Amendment right. I believe this is what it is. She's arguing timely, and she's coming back and saying, all right, in all of these other filings, this is what I did. And this is ECF 152, and this is what the court overruled on. I'm also looking at, she says the court has also recognized that anonymous speech is protected by the First Amendment and has acknowledged the safety concerns associated with identity disclosure, including permitting the use of registered agent address. Findings further support the importance of careful scrutiny before compelling disclosure. Finally, the posture of the case materially changed. So she's arguing the case of a number of things here. For all these reasons, defendant respectfully requests that the court sustained defendant's objections under Rule 72, set aside magistrate judge's order compelling identity disclosure. So I'm correct, it's 144. Stay enforcement of the identity disclosure requirement pending review and grant any further relief the court deems just and appropriate. All right, so I wanted to find ECF 144 just so you could see what was the conclusion of Judge Elizabeth A. Stafford, what 144 is. The court thus grants Evans' motion for an order to show cause, ECF number 134, by March 24th, 2026. Robertson must show cause why she should not be held in contempt and sanctioned for her defiance of Judge Levy's order to disclose her legal name and postal address. So we go to ECF 150 now and see if in her argument she is saying today, and again, this is my words, that she wants to know if ECF 150, which she's titled her show cause, if that is going to be considered in the record before she, well, it's in the record, on the record, make any ruling on the contempt and sanction. I think I have that correct. All right, so now let's go to 150. This is a working live. So had I not come on at 8 o'clock, I would be going through all of this and maybe coming on at 10. I don't know. Or talking about something else, but this is what we're doing together. All right, so now let's go to 150. This was filed on March 24th. So let's see if this is the response to the magistrate judge's ECF 144 to show cause. It's titled Defendant's Response to Order to Show Cause. Let's go through that. Let's you know what I want to look for are, and I can't search on this one, are words like contempt and sanctions. A response directly why she should not be held in contempt and sanction for noncompliance and defiance of the court's previous orders. All right, so let me just scan real quick. Let's see. Compliance with judicial process and good faith. Defendant sought judicial review through proper procedural channels. Does this answer why she shouldn't be held in contempt and sanctioned? That's what we're looking for. All right, here we come to this. Section 7. Let's see if she answers it here. The standard for contempt or sanctions is not met. All right. Defendant respectfully submits that the record reflects good faith reliance on established procedural mechanisms and a reasonable effort to obtain judicial review before complying with an order requiring irreversible disclosure of identity. Here it is. The present circumstances therefore reflect a legal dispute regarding compliance while review is pending, not willful disobedience of the court's authority. Civil contempt requires clear and convincing evidence of a violation of a definite and specific court order. Well, there's been two. Defendant recognizes the general principle that court orders must ordinarily be obeyed unless stayed or reversed. However, defendant sought review and a stay through Rule 72A objections and related motions rather than disregarding the court's authority. All right. It is not appropriate where there is a fair ground of doubt as to whether compliance was required under the circumstances. Good faith efforts to seek judicial review or comply through available procedures weigh against finding of contempt. See Electric Workers Pension Trust Fund versus Gary Electric Service Company, 340 F3D 373 and 379, 6th Circuit, 2003. The record demonstrates that defendant filed objections to Rule 72A, filed a motion seeking a stay of enforcement, previously sought protective relief from the court, and continued to participate in the litigation through filings and responses. At most, the present situation reflects a legal dispute regarding compliance while review is pending, not willful disobedience or contempt. So here this is what she's saying. Her argument that a legal dispute, that's what she's calling. She basically disagrees with. This is my words. A dispute. She asked for a stay. She asked, to have review before unmasking. The court has ruled on this multiple times. Then she says, at minimum, I'm talking about within this brief arguments that she has presented to the court before. At minimum, the record reflects a fair ground of doubt as to the timing and propriety of compliance. And she goes into more arguments. The court has addressed time and time again, and she brings things up time and time again to get them into the record, my opinion. That's why I'm not doing a deep dive. All right, so this sentence here. This further demonstrates that defendant's conduct reflects a good faith legal position grounded in evolving law and public policy, not willful disobedience or contempt. Will she reveal her identity and her postal address, her anonymity? there's more arguments. And there's more today. There's more. There's more motions. This time she wants clarification. All right. I'm not, because this just came in. I'm not going to give my response on air to her specific arguments in her filing today. So I'm just, generalizing because it just came in today. I was at this part. This further demonstrates that defendant's conduct reflects a good faith legal position grounded in evolving law and public policy, not willful disobedience or contempt. So that's her response. Even if the court ultimately disagrees with defendant's position, the record reflects reasonable, good faith conduct under evolving legal standards. In other words, her argument, there's just can't be any bad faith. That's it. It's my own words. It's my interpretation in that one sentence. Even if the court ultimately disagrees with defendant's position, the record reflects reasonable, good faith conduct under evolving legal standards. So you can disagree, Your Honor, but this is what the record shows. It's just my own interpretation, okay? I could be all wrong. I'm the plaintiff, I'm not giving my arguments. Just my reaction. Defendant does not seek to evade the court's authority. Rather, defendant seeks to ensure that compliance occurs in a manner consistent with governing law and the court's review of the pending objections. Well, the court ruled. Orders. She says defendant does not seek to evade court's authority. Rather, defendant seeks to ensure that compliance occurs in a manner consistent with governing laws and the court's review of the pending objection. So then my question, you see where I was kind of going. If the court reviews everything and still comes back, she's done her judicial review thoroughly, are you going to comply? Hang on, please. See if I can find out. Let's we're looking at ECF 150. We're at the conclusion. This is the defendant's response to show cause, ECF 150. That's what the title is. Does she show cause why she should not be held in contempt and sanctioned? I pointed to section 7, those few paragraphs. Is that sufficient? I don't know. It's the court. It's up to the court. I'm just simply showing you what she's arguing and what she filed. She wants the court to clarify. Conclusion. Defendant recognizes the court's authority and respectfully submits this response in order to comply with the court's directive while preserving her right to seek judicial review of the issues presented. Even if the court disagrees with the defendant's legal position, the record reflects good faith conduct, not sanctionable behavior. Defendant respectfully submits that the record reflects a good faith legal dispute regarding the timing and propriety of compelled disclosure, not defiance of the court's authority. Because defendant sought review through Rule 72, objections, and a motion to stay, the elements necessary for contempt or sanctions are not present. So in here, she's arguing more about that as well. Defendant therefore respectfully requests that the court discharge the order to show cause, decline to impose sanctions or contempt findings, and defer enforcement of the identity disclosure requirement pending resolution of defendant's Rule 72 objections and motion to stay, ECF number 148. She ruled on those. Let's just see. Back to my PACER report. All these filings, you can see how it can be, a lot to go through, a lot to thread together and keep, organized and refer back to.
Just to be loved, that is all. 사실은 다시 sweet, sweet heart after all. Can't help it but fall in love. Can't help it but fall in love. Can't help it but fall in love. 눈물마저 사랑스러워. 사실은 다시 다칠까봐 두려워. 사랑이라면 다친데도 괜찮아. Samantha, Samantha, she's got a sweet, sweet heart after all. She's got a sweet, sweet heart after all. tak한 사람만 바라보고 있잖아. 사랑받아 마땅한 그녀.
Woo. Hey, my emails are on fire tonight, just like that fireplace. Jeez. Are they on fire tonight? Yeah, it's a good thing I came on early. They on fire tonight. Did you like that one? Rock and roll. You didn't think I liked some good headbanging AC DC? You know, good music is good music. And that is great. That's going to do it for me. That one was called Thunderstruck. That's kind of what those emails felt like. All right. That's it. Thanks for watching again. Yes, I went hard. Rock and roll. That's what we should turn this into. Yeah, music that. Get some headbangers over here. Interacting. All right. Thanks. All right. Thank you to my moderators, Baby Juju and Vicky Black. That's going to do it for me. Time to say good night. Good night. Wow,